Anyway, so after New College Berkeley, a master's degree in Christian ethics or something, then he went to Duke University and studied with one of the greats in Christian ethics, Stanley Hauerwas, and others. And then he came back to Berkeley, went to law school, got his law degree at Berkeley, and then has been in group practice, and then finally individual sole practice in Boulder, Colorado. And so Ken is here to talk about the technicization of law. So Ken, welcome up here. Let's applaud. Come on.
My right ear is plugged with some wax this morning, so I probably should have this over on the other side, but it's okay. I can hear still. If you ask me a question and I don't turn, it's not because I'm ignoring you. I'm just not listening. I should say too, I really enjoyed being at New College Berkeley, and I went on to Duke and studied. And New College was it was tough. I mean, the professors were hard on you. You learn an awful lot. I went to Duke, and it was a breeze. I just went like breeze through there, and I always remembered New College as the place where very formative with David and with the other professors there, and learning about being a Christian layperson. And I was kidding the other day that I decided to go into law. I went to Duke thinking I would study and be a professor in theology and ethics, but I ended up going to law school. And the reason why is because a professor at Duke said, well, it's great if you want to be a professor, go do it by all means, but if you can think of anything else that you would be happy doing, you should think about doing that, because it's a long haul to be a professor, and if that's not the thing you really want to be, think about doing something else. And so I took that advice and I went to law school. But I think looking back on it, probably because Ellul was so interested in law and was a lawyer, I was influenced by that in making that decision, because I had never really thought about going to law school before I went to graduate school, but I ended up doing it and I really enjoyed it. So what I'd like to talk about today, and I want to tell you the main points they want to get across before I read my paper, so you have in mind what I'm trying to do here. And they have 4 main points that I want to get across. Number 1, that human law is a technique. It's not an art. It's not a theological. And Charles Darrow may have disagreement with me about this, but I don't think it's something that you draw from theology or from the will of God or the instruction of the Old Testament or New Testament. Law is a technique, and that's what Ellul believed. Second, law is a unique human phenomenon in that it does not separate the ends and the means. And I'll explain to you further when I read the paper. There's no other human phenomenon that does that, and Ellul characterized it as a unique human phenomenon. He liked to say that technique and values do not interact in human society. But I beg to differ, because he said law required both values and technique in order to be law, in order to be applicable and normative in society. And if the law does not have values that the society adopts and accepts as their own values, and if it does not have procedures, in other words, techniques, to implement those values, make them effective, it's not law. That's what Ellul ended up concluding after studying it for a number of years. But the final point is that as society adopts technicist values, and I think Ellul convincingly argues that society is in the process of adopting technicist values, then, and you'll see why, but law will then assume those values as part of its structure, and it will assume juridical techniques essentially, commensurate with those technicist values. So law has the ability, if it has human values and not technicist values, to somewhat fight off technique in society. But if it adopts technicist values of efficiency, order, adaptation, all the ones that we've talked about over the course of this conference, then the risk is that law accelerates technique in society. And that's what I'll talk about during this discussion. So I'm going to read you, and I'm going to go through it quickly because I know I have a limited time. And here we go. In the Technological Society, Ellul refers to human law as one of humanity's, quote, highest vocations. Elsewhere, Ellul spoke admiringly of law as an indispensable element in the creation of all civilization. He asserted that law occupies, quote, the privileged place in the ever-renewed search by man for values which give meaning to his life. He declared law unique among all human phenomenon in that there is no dissociation in the law between ends and means. As a result, Ellul initially appeared to credit law with the ability to resist technique to some extent. He wrote, quote, judicial technique is in every way much less self-confident than other techniques. That was in the Technological Society. In the context of law, he wrote, technique assumes the role of a handmaiden modestly resigned to the fact that she does not automatically get what she desires, close quote. On the other hand, in a 1975 lecture, Ellul referred to law as, quote, not far from the demonic. He went on to say that l'adroit, law, becomes demonic when it claims to occupy the whole place, and unfortunately, law always finally claims to occupy the whole place, close quote. So what are we to make of Jacques Ellul's various interpretations of the law in the context of the technological phenomenon? Before I can answer the question that I set out to answer in my paper, the technicization of law, justice, and the practice of law, I think it's important first to review briefly Ellul's interpretations of the law. So as far as his, and I'm not going to focus very much on his theological interpretations of the law, but suffice to say that he made a number of shifts, and he acknowledged it in a 1985 workshop in Pessac, France. He admitted that his study of the law was the one area that he was not satisfied with. On that occasion, Ellul stated, quote, law, for me, is the area where I have never managed to do something that satisfied me. It's really the only area. It's the only point. I have varied 5 times in my interpretation. This is the only point of my reflection where I have varied. So that was his reflection back towards the end of his life about how he addressed, how he analyzed law. And he goes on that occasion in a few short summary statements explaining his 4 categories, or his 4 interpretations, and they all really have to do with his theological interpretation of the law. But he noted that he was anticipating a 5th stage, and I'm not aware of any written statement, or maybe if I went and looked at the archives at Wheaton, I would find another statement about what his 5th theological interpretation of the law consisted of. But he made the comment that the law, human law, addresses 3 existential questions facing human beings. And those have to do with temporality, time, we exist in time, space, we exist in property, we need to address the issues of property and where we are in space. And we also have to deal with questions about how to deal with other human beings, relationship with human beings. He said the law addresses those 3 issues. That was what he had concluded. These were 3 existential questions that every society in every era needs to address, and the law addresses those 3 questions. But he pointed out in this 1985 workshop that those were also 3 existential questions that the biblical revelation addresses. And he didn't understand how that could be. He said, this is truly one of the most difficult problems. And he was trying to figure out how both biblical revelation and society address those 3 questions. And he implied that the resolution of this thinking that he was conducting at the time would be his 5th stage of his theological interpretations. So let's set aside theological interpretations. Now I'm going to talk about his sociological interpretations of the law. It was not nearly as variable as his theology of law. His earliest reflections describe law as arising from the human experience of living with others. He viewed human law as originally based in religious and social customs that are spontaneously followed because they are integrated into human social life. As society develops, he believed that they inevitably become aware of these customs, the human beings inevitably become aware of these customs, and as a result, these customs become the object of speculation and organization into legal and administrative rules, legal doctrine, jurisprudence, policing, legislation, and case law in a broad sense, all of which Ellul refers to as juridical technique. Ellul described this process in an early personalist article on law. He wasn't talking about, it's interesting because he's not talking about technique here, he's talking about how law develops into law. And he says, as soon as any human phenomenon becomes conscious, i.e. we become aware of it, it enters into a network in which it loses its character of spontaneity. And once people have become aware of it, it becomes obvious and then understood. Once understood, it becomes reasoned, and once reasoned, it becomes willed, and it ceases to be real and becomes instead a process. Now, readers of the Technological Society will recognize this as how he described the technological phenomenon as developing, generally. But from the beginning of his study of the law, Ellul recognized that the more society evolves, the more the spontaneous character of law disappears, and the more the law becomes embodied in juridical technique. Now, initially, Ellul viewed juridical technique as a phenomenon that corrupts human law, which spontaneously arises from communal customs and human conscience. In the earliest stages of its development, Ellul viewed juridical technique as having a limited impact on law. In comparison with other techniques, this is where he spoke of juridical technique as much less self-confident than other techniques because it is in tension with law's sense of justice, which Ellul believed was impossible to translate into technical elements. Therefore, Ellul viewed law as somewhat resistant, although not immune to the effects of technique, as long as the pursuit of justice remained in equilibrium with juridical procedures in law. But by the time he wrote the Technological Society, Ellul believed that any equilibrium between the human and the technical elements of law had been lost, and juridical technique had taken over. At least, he wrote, among nations that have a less firmly rooted legal sense than the French, which I found very amusing. Ellul's sociology of law changed in two important aspects after he wrote the Technological Society. First, he moved away from his earlier view that a communal sense of justice was the sole basis for human law. He developed a broader basis for law as assuming the dominant common values of a society in which it is found. And it doesn't necessarily have to be justice, it could be other values. And second, he recognized that human law itself is a technique, and he concluded that juridical technique is one of the defining elements of law rather than a phenomenon that corrupts law, which I found was an interesting shift. He started out thinking that you've got this pure living law that's driven by the sense of justice, and technique is coming from the outside trying to corrupt it. And then he reached a position later on, after studying law from a historical, sociological perspective, that technique itself was the critical element of law, juridical technique. Now, both of these changes that I just described derive from his efforts to understand how law is created generally in societies. So in the 1960s, Ellul's socio-historical study of the relationship between human beings and law in their lived social reality led him to confirm that law is a universal phenomenon that is found in every period in civilization. Ellul reasoned that because law is a universal human phenomenon, it must be based on universal human experiences, and that the only such experiences are those of time and temporality, space, and human relationships. That's what we talked about earlier. He concluded that these are the three challenges that human beings encounter in all societies and in all times, and ultimately that the law is an adequate response to these challenges. But this theoretical account of law's origin was insufficient for Ellul to explain law's normativity in society. Normativity is, that this is something that is a norm for how people should act. For Ellul, what makes law normative is that it assumes the common values found within a society. He writes, quote, "Law is never normative in itself, but exclusively by its reference to the values accepted by the social group. Thus, as long as the group believes in its values, the law which explains them is normative. And then he goes on to say the individual only feels validly judged if the law is based on values which he himself, the individual, accepts. Otherwise, he can only feel injustice. This is simply due to the fact that the individual recognizes as legitimate the measurement of his act based on an objective rule which becomes subjective for him when the values it carries are also those that he carries himself. It was at this point that Ellul shifted his earlier emphasis of law based in a sense of justice to law based more broadly on society's common values, whatever those happen to be in a given place and time. Thus, if a society's dominant values are other than justice, for example, freedom or order or security or some other value, then the law must assume that value in order to be accepted as law. As a result, Ellul did not think that you could reject a functioning legal system as non-law simply because its content failed to conform to your own moral standards. If law assumes a society's dominant common values and has a positive representation in that society, then the law is no less normative and applicable than law in other societies based on other values. And he gives the examples of Nazi Germany and Soviet Russia. So from the beginning of his study of the law, Ellul recognized that law cannot limit itself to simply recommending values. It also must create juridical procedures to put those values into practice and to make them concrete. Ellul initially viewed this development as a corruption, as I pointed out earlier, a corruption caused by technique rather than any internal necessity of the law. But once Ellul determined that law requires the assumption of the society's common values in order to be normative, he concluded that law requires, quote, the choice and development of ways and means to bring its assumed values to a certain degree of effectiveness. And I thought that was interesting. He says you've got to have procedures, juridical procedures that are commensurate with the values in order for the law to be effective and in order to make those values take effect. As society progresses, it is no longer feasible for its customs and values to be spontaneously followed. So at that point, the values need to be embodied in juridical procedures and rules. And here is where Ellul made his second significant shift. He came to view juridical procedures, which he conceded in his writings were, quote, what he called close to the techniques, close quote, and which he previously viewed as corrupting law, as the essential fact, he called, these procedures are the essential fact of the law, and, quote, the most important part of the law. Thus, Ellul concluded that law does not actually exist as law until the point at which juridical procedures are introduced. This led Ellul to describe law as not a system of norms, but a system of implementing common values. And Ellul made it clear that his emphasis at this point was on the implementation. Ellul wrote that the law assimilates values, and it is they which define the law's normativity. But law assimilates them by giving them a procedural form which allows their application to be conceived and planned. So Ellul came to see the central question regarding law as not whether law is created by human beings to be normative, but rather whether it functions as normative, that is, whether it becomes applicable by modifying individuals' conduct and their social reality. Ellul moved away from his earlier position that legal sanctions are what make law applicable. He ultimately concluded that law is applicable in society not as the result of sanctions, but as a result of the individuals who make up society having a positive representation of the law and therefore accepting and living it. This positive representation only exists where ordinary citizens perceive the law as not only conforming to their values that they recognize as their own, but also presenting juridical techniques consistent with those values. For Ellul, the law can never be taken in itself as a realization of value. It is rather a possibility offered to man to achieve the realization of value. Thus, each citizen's personal representation of the law is chiefly influenced by their personal contacts with the law's juridical techniques. In the widest sense that we discussed earlier, the policing and administration and legal precedent and regulations, all of which are created to realize the law's assumed values. If citizens personally experience these juridical techniques as being consistent with society's dominant values, then the citizen will hold a positive representation of the law, and the law will be applicable in society, according to Ellul. Ellul summarizes a citizen's positive representation as follows, quote, "If I obey this legal rule, which expresses a value which I recognize as mine, then I can create a situation of justice or of order or of peace or of some other value that they hold dear. But I cannot obey this rule if I do not recognize the value it expresses." Because Ellul came to view juridical techniques as critical for law's applicability, he concluded that the most important element of law is the juridical techniques that it adopts. Ellul's sociological study led him to conclude that law is unique among human phenomenon because in law there is no dissociation between ends and means. In order for the law to be applicable, its juridical techniques must always be consistent with the values that the law assumes. So for Ellul, this relationship between law's assumed values and juridical techniques is critical for society's continued existence and society's continued existence and development. Ellul viewed this relationship as dialectical because it enables law to mediate contradicting positions and generate syntheses at all levels of society. On the one hand, the law involves choices among all possible values, which are never static in society, and on the other hand, the law involves choices of procedures that make its assumed values operational in society. At the individual level, law mediates contradictions by imposing delays, procedures, and intermediaries. Ellul writes, "The victim does not take revenge immediately themselves by pure violence, but after a certain delay through somebody acting as intermediary, an arbiter, a judge, a third party, or a tribunal, and according to certain established forms." At the social level, law mediates contradictions that arise between diverse social groups, political powers, and evolving social values by bringing them to livable compromises. This tension is both the strength and ultimately the weakness of law in relation to the technological phenomenon. Law's strength is that in order to be both normative and applicable, it must always keep juridical technique consistent with its assumed values. Juridical technique can never be separated from the law's assumed values without creating a negative representation for individuals in society, and therefore causing law to be inapplicable. Thus, depending on what common values the law assumes, law's values are able to resist the technological phenomenon to a lesser or greater extent. For example, Ellul wrote about, quote, "the perpetual problem of justice in the technological society." Ellul refers to technique as a modest handmaiden in the context of the tension between juridical technique and justice. This is where Ellul writes that juridical technique is in every way much less self-confident than the other techniques, because it is impossible to transform the notion of justice into technical elements. As a result, Ellul saw the potential for an equilibrium between juridical technique and traditional social values, which allows juridical technique to be held in check. But on the negative side, Ellul saw that the law's need to assume evolving social values and commensurate procedures as making it an, quote, "inherently precarious creation." Ellul warned that law was becoming increasingly detached from traditional values as a result of the technological phenomenon. Ellul saw this as causing law to become non-law because it results in law losing both its normativity and its applicability in society. But I beg to differ here. This is where I depart from Ellul. He's, in fact, as he points out, simply because a functioning legal system's content fails to conform to certain moral standards does not mean that it becomes non-law. If a society's values are progressively becoming the technicist values, then the process Ellul describes is not law becoming non-law. Rather, it is law evolving by assimilating society's changing dominant values and providing commensurate procedural forms to implement them in order to remain normative and applicable. Thus, while law has a unique ability to somewhat resist technique when it assumes traditional human values, it also has the potential to accelerate technique in modern society by reinforcing technicist values and adopting commensurate juridical procedures. So now we can answer the questions about the technicization of justice law and the practice of law. First, is justice becoming technicized? Having reviewed Ellul's sociological interpretation of law, we can now look at those three questions. And from an early point, Ellul acknowledged that the role of justice in human law presents the greatest of difficulties, mainly because of its ambiguity. As a result, Ellul deemed that it is almost impossible to determine the nature of justice from a human point of view. And that's a quotation. In the technological society, Ellul contends that, quote, despite what philosophers may say, justice is not a thing which can be grasped or fixed. He therefore concluded that it is impossible to transform the notion of justice into technical elements. Likewise, in The Political Illusion, Ellul writes that, quote, concepts of justice and its content vary greatly among civilizations and even individual points of view. Let us therefore leave aside the problem of juridical justice and even that of social justice, the ambiguities of which are well known, close quote. So once Ellul became to understand that law as assuming society's dominant values and techniques based on those values, he no longer viewed law as necessarily based in justice. Or rather, while Ellul recognized that the idea of justice is continually held up as a criterion of law, he acknowledged that a society's dominant values may reflect differing views of what justice consists of. In other words, justice could mean equality or order or freedom. And those values evolve over time. In 1973, he wrote, "There is no point in saying that the law must express, for example, justice. What is important is to ask ourselves if the group recognizing justice as its dominant value, if the group recognizes justice as its dominant value, and if this is recognized, to know what the group puts under the word justice." In view of how Ellul came to understand law, the question whether justice has become technicized misses the point. While Ellul asserted that there is no relationship between the proclamation of values, justice, freedom, etc., and the orientation of technological development, his sociology of law necessarily qualifies that assertion. Ellul came to see law as a unique human artifice that requires both human values, not necessarily justice, and technical means reflecting those values in order to be normative and applicable. The law is therefore the one area in society that human values are in direct relation with technical development. Thus, the more important question is, what are society's dominant values assumed by law, and are those values becoming more and more the technicist values? Ellul viewed technique itself as increasingly becoming a value in society, with a whole system of subordinate values corresponding to the operational needs of the technological system. As society's values evolve more in this direction, the law, in order to remain normative and applicable, must assume these technicist values and adopt juridical techniques commensurate with them. The more society adopts technicist values, the more law assumes these values, and the more law reinforces and accelerates the technological system. Ellul saw the technicization of law as manifesting in a number of ways. First, as law assumes more technicist values, it increasingly assumes juridical procedures based on technicist values rather than on traditional values. Second, technicized law follows techniques characteristic of self-proliferation. In order to carry out this self-proliferation efficiently, the modern state takes over the creation of law. The state creates a proliferation of detailed laws and regulations that can be applied automatically by the courts in an effort to eliminate any unpredictability and subjectivity in judgment. This results in the common law tradition of case precedents having less and less independent value. Third, the role of judges and lawyers in the creation of law progressively decreases, and they instead act as merely technicians who apply the law. As a result, law is less and less able to bear the dialectical tension between traditional human values and the juridical techniques necessary to mediate contradicting positions in society. Fourth, the state's enormous proliferation of laws seeks to regulate all areas of society, which results in the law becoming incomprehensible to all but the legal expert. Fifth, the fact that the law is under state control means that it undergoes repeated changes as new sets of politicians repeal laws adopted by their predecessors and adopt new laws. The result is that society no longer views law as a stable and permanent representation of society's values, and this threatens law's normativity and applicability. All of these symptoms of technicization are evident to a lesser or greater degree in law and the practice of law in modern societies. Ellul's express purpose in writing The Technological Society was to diagnose the multiple problems that the technological phenomenon presents in order to, quote, arouse the reader to an awareness of the technological necessity and what that means. Ellul warns in his author's foreword to The Technological Society, the reader may be inclined to say that if everything happens as stated in this book, man is entirely helpless either to preserve his personal freedom or to change the course of events. Once again, I think the question is badly put. I would reverse the terms and say, if each one of us abdicates his responsibilities with regard to values, if each of us limits himself to leading a trivial existence in a technological civilization with greater adaptation and increasing success as his sole objective, if we do not even consider the possibility of making a stand against these determinants, then everything will happen as I have described it, and the determinants will be transformed into inevitabilities. Ellul's warning against abdicating our responsibilities with regard to values applies directly to law and the practice of law, because he identifies law as the only area in society where values are in direct relationship with technique. Ellul saw lawyers as occupying a unique position that allows them to function as creators of law who recognize society's human values and work to embody them in commensurate juridical procedures and practices. But even more important than the lawyer's unique position to positively affect citizens' representations of law, the lawyer must work to increase human elements in law in order to counter its increasing technicization. Because Ellul viewed law as a, quote, testing ground for values, close quote, he emphasized the importance of the lawyer's role in choosing the values for law to assume and the procedures to implement those values. These choices are critical for society's ability to progress. To the extent that the law's assumed values and procedures defer to the technicist values of efficiency, order, and adjustment, Ellul saw society heading toward a dead end. This is the situation that arises where lawyers act merely as technicians of law. On the other hand, if lawyers rediscover their role as the only true creators of law and work to bring human values back into their practice, then Ellul believed that law could again become a living law that would be able to fulfill its necessary mediating role in society.